our webinar dealing with EMTALA issues today. This is the next in a series of webinars that we are doing dealing with compliance-related issues. We've covered a lot of different topics. We're reaching the end. Today I'll be talking about EMTALA. Next week I'll be talking about creating, managing, and terminating patient relationships. We'll talk about some antitrust issues and wrap it up with FDA regulatory issues. For those of you who participated or those who would like to receive information about the past webinars, those are all recorded. The materials are available on our website. You can just access those. Those are all free as a courtesy to our clients and friends. These are the things we're going to be talking about today. We're going to talk about to whom and when EMTALA applies, the requirements for hospitals with emergency departments, the requirements for receiving hospitals, patients who refuse exam or treatment, what do you do about those, how you document that, on-call physician responsibilities, documentation requirements, and avoiding EMTALA penalties. You should have received a link with the written materials that we've got for the program, including the PowerPoint slides, as well as the EMTALA regulations and interpretive guidelines, and a couple of articles that I've written on EMTALA. If you haven't received those, just let us know and we'll make sure that you get copies of those. A couple of preliminaries. This program provides an overview of relevant laws. Just remember that there may be additional laws that apply in your particular state. Some states have their own version of EMTALA, and so if that creates greater patient rights, you may have to comply with your state law. In addition, different courts or jurisdictions may have different interpretations dealing with EMTALA, different cases concerning EMTALA. So make sure you're familiar with that. And finally, CMS may have, your particular region for CMS may have its own interpretation concerning some of the EMTALA issues. The bottom line is make sure that when you're addressing EMTALA issues that you consult with qualified experts who understand the particular circumstances in your particular jurisdiction. If you have questions during the program today, because the program is recorded, we won't take questions, but you can shoot those questions to me either using the chat feature or using the online feature, or just sending me an email, and I'll go ahead and respond offline. With that said, let's talk about EMTALA. EMTALA is actually short for the Emergency Treatment and Active Labor Act of 1986. A little bit of background about EMTALA. EMTALA arose out of as a result of some pretty egregious situations where a patient may show up at the hospital, but because the hospital had no ongoing patient relationship with that patient, the hospital really wasn't required to accept the patient or take the patient. Instead, these people may have a gunshot wound lying on the steps of the hospital, and the hospital allegedly didn't do anything to care for that particular patient. Well, the government got involved and passed EMTALA in 1986. The statute is found at 42 USC 1395 DD. In addition, the government made these EMTALA part of the conditions of participation for hospitals. And if you fail to comply with EMTALA, as we'll talk about in just a minute, then you can get hit up with civil monetary penalties that are found at 42 CFR 1003.103 and 106. Because they are part of the interpretive or the conditions of participation, the government has issued interpretive guidelines dealing with EMTALA issues. Those are found at the State Operations Manual revised, that was recently revised in 2019, dealing with the EMTALA issues. That's kind of the best source to go to if you want to know what your obligations are as a hospital under EMTALA. Let's talk about to whom EMTALA applies. EMTALA applies to hospitals that participate in Medicare. It only applies to Medicare participating hospitals. That's most hospitals, but I suppose there may be some specialty hospitals that don't participate in Medicare. If that's the case, then they do not have to worry about EMTALA, at least on a federal level. Now, EMTALA applies to two types of hospitals that participate in Medicare. The first is if the hospital has a dedicated emergency department, then there are certain requirements. EMTALA also applies to hospitals with specialized capabilities, even if they don't have a dedicated emergency department. If the hospital has a dedicated emergency department, then they generally have to provide the appropriate medical screening exam, stabilizing treatment, or appropriate transfer. The key there is whether the hospital has a dedicated emergency department. EMTALA defines a dedicated emergency department as that it is licensed, that facility is licensed as an emergency room or department, or it's held out to the public as a place that provides emergency care without appointment. And in the commentary, the government has stated that that would apply to most urgent care centers that are operated as provider-based by a hospital, that in most of those situations, those hospitals are holding out that urgent care center is a place that people can go for emergency type, urgent type care without an appointment. The third criteria or alternative criteria is if that facility during the prior calendar year provided at least 1/3 of outpatient visits for emergency conditions on an urgent basis without a prior appointment, then that facility may also constitute a dedicated emergency department. If it's operated by a hospital, then EMTALA would apply. Bottom line here, EMTALA is not just limited to your emergency departments. It could include other areas within your facility and even off-site facilities like urgent care centers if it's operated as provider-based, as a provider-based department of the hospital. Now, EMTALA also applies to hospitals with specialized capabilities. The rules are a little bit different there. We'll talk about that later. So even if the hospital does not have a dedicated emergency department, if that hospital participates in Medicare and has specialized capabilities, then it is going to be obligated to accept transfers of patients. Now, EMTALA not only applies to hospitals, EMTALA, per the statute, specifically also applies to physicians who are responding to potential emergency medical conditions, including on-call physicians, that they have responsibilities and can be liable and subject to penalties if they fail to comply with those requirements. What are those penalties? Well, because EMTALA is part of the conditions of participation, the government could come in and terminate the Medicare provider agreement and exclude the providers from participating in Medicare or Medicaid. That's usually the most common enforcement route. If there is an EMTALA violation, the surveyors will cite the facility, and the facility will have to engage in a plan of correction, and usually that resolves it. It's possible, however, that the hospital and also physicians could get hit up with civil penalties. The penalties differ for hospitals. If the hospital has less than 100 beds, then these penalties were actually doubled recently. The current, and they're subject to an annual adjustment, the current adjustment, at least from 2020, is that if you have if you're a hospital, you have an EMTALA violation, you have less than 100 beds, the penalty is up to $54,833 per violation. If the hospital has 100 or more beds, then it's up to about $112,000 per violation. For physicians who violate EMTALA, the penalty can be up to about $112,000 per violation. Now, in addition to those civil penalties, hospitals may be sued for damages under EMTALA. There is no private cause of action against physicians under EMTALA, but there is against hospitals. Hospitals could be sued for damage by individuals who suffer personal harm. So if you refuse to accept that patient, the patient suffers adverse consequences, that patient could sue you. In addition, if you fail to provide services at your facility and that results in damages to another facility, maybe because that patient showed up at another facility or you improperly transferred the patient and that other facility has suffered damages, that other facility can also sue you for their financial loss. That doesn't occur very often, but it's out there. Well, what are the EMTALA requirements? In general, hospitals with a dedicated emergency department must provide to those patients who show up at their facility an emergency medical screening exam. If that exam indicates that the person has an emergency medical condition, they've got to provide stabilizing treatment for that emergency condition or an appropriate transfer of unstabilized persons to another facility. If the hospital, even if it doesn't have a dedicated emergency department, if it participates in Medicare and it has specialized capabilities, that hospital must accept a transfer of unstabilized persons. If they fail to do so, they could violate EMTALA and be subject to penalties by CMS. In addition, the facilities have to delay the exam or treatment to inquire about payment. You must post certain required signage, and you must maintain required documentation, including your on-call list and the ED log. We'll talk more about that later. That's a brief overview. Well, when is EMTALA triggered? Well, for hospitals with a dedicated emergency department, EMTALA is triggered if a person comes to the emergency department. That's the buzzword. The person comes to the emergency department and a request is made for emergency care, and the person is not already a patient at the hospital. For hospitals without a dedicated emergency department, for example, specialty hospitals or other facilities, EMTALA is triggered if the hospital participates in Medicare, the hospital has specialized capabilities that are needed for a particular patient, and the hospital receives a request for transfer from another facility to that particular hospital. So for those hospitals with a dedicated emergency department, EMTALA is triggered if the patient comes to the emergency department, which means that they're on hospital property. That is defined under EMTALA as the patient is on the main campus of the hospital, including the parking lot, sidewalk, and driveway of the hospital. Okay, so it's the whole main campus of the hospital. It also includes areas within 250 yards of the hospital that are owned by the hospital, for example, provider-based departments. So even if a person shows up at an urgent care center, that urgent care center is not on the main campus, but it's within 250 yards of the hospital, or actually any other facility that's owned and operated as a provider-based department of the hospital, including physician clinics or offices, if they're provider-based. If it's within 250 yards, then EMTALA would also apply if the patients show up at that facility. It also applies if the patient shows up at an off-campus facility that is itself a dedicated emergency department. That could be, again, an urgent care clinic. It could be a labor and delivery suite, something like that. Even if it doesn't have a quote-unquote licensed emergency department, if that facility satisfies the definition of dedicated emergency department under EMTALA, then EMTALA would apply if that patient shows up at that other facility. Now, the following are not considered part of the hospital for purposes of EMTALA. So if the patient shows up at these places, EMTALA is not triggered. It would include areas or structures that are not part of the hospital, for example, independent physician offices, rural health clinics, skilled nursing facilities, or other facilities that do not operate under the hospital's provider number. So EMTALA generally tracks the provider number. The government says, look, if you're going to operate as part of the hospital and the provider number, you get increased reimbursement for doing that. But the downside is then you're also going to be subject to EMTALA. On the other hand, if you're not operated as part of the hospital, so you're not operated as a provider-based department of the hospital, like an RHC or SNF that have separate provider numbers, then in those situations, EMTALA would not apply if the patient shows up at those facilities. In addition, EMTALA would not apply to an off-campus facility if that facility does not have a dedicated emergency department. Even if it's owned by the hospital, if it's an off-campus facility and does not have a dedicated emergency department, then EMTALA would not apply if the patient shows up there. There may be other obligations under the conditions of participation or malpractice rules or things like that, but EMTALA would not apply in those situations. But what about ambulance? Well, here's generally the rules for ambulances. If the air or ground ambulance is owned and operated by your hospital, then it's considered to be part of your hospital. That means that EMTALA applies to your hospital if that patient is in your ambulance, unless the ambulance is operated under a community-wide EMS protocol or at the direction of a physician from a different hospital. So what does that mean? That means that if you, as a hospital, own and operate an ambulance, you send that ambulance out to pick up somebody, even if that person is not back physically at the hospital's main campus, that ambulance is considered part of the hospital. That means that that ambulance cannot transfer or take the patient someplace else unless you jump through the EMTALA hoops. Unless, again, it's operated under community-wide protocol or that ambulance is operating in the direction of a physician from a different hospital. General rule, though, is just consider this. If you own and operate an ambulance, that ambulance is part of the hospital, so that EMTALA is triggered if that patient is in your ambulance. If the ambulance is not owned and operated by your hospital, well, the rules are a little bit different. EMTALA would apply certainly if that hospital, to your hospital, if the ambulance is on your hospital property. So the ambulance, even though it's not your ambulance, if they bring you back to the facility and that ambulance is on your property, then EMTALA applies. Generally, EMTALA is not supposed to apply if the patient's not in your ambulance and not on hospital property. However, the EMTALA regulations have kind of a curious statement in there that says that you may divert an inbound ambulance if you are on diversionary status. In a case from the Ninth Circuit, the court said, well, that must mean then that EMTALA applies and prohibits you from diverting an inbound ambulance unless you're on diversionary status. So general rule there is, unless you're on diversionary status, you can't divert an inbound ambulance. That's probably the safest thing to assume, even though this was a Ninth Circuit case. Even if you're operating in other cases, it would be safe, other jurisdictions, it's safest to assume that if that patient, even if it's not in your ambulance, if it's inbound, you can't divert that ambulance to another facility unless you're on diversionary status. Well, what is diversionary status? No real definitions under the regulations, but it generally means you lack staff or facilities to accept additional emergency patients at your particular facility. Your capacity, that determination of whether or not you're properly on diversionary status, depends on the staff, equipment, and supplies you have available, the number and availability of beds, and your past practices in accommodating additional patients in excess of your occupancy limits. For example, in the past, and in the interpretive guidelines, they've made it clear that in the past, if you've done things to accommodate and increase your capacity, such as moving patients to other units, calling in additional staff, borrowing equipment, or things like that, well, that is considered a part of your capacity, and therefore you would need to consider that in making the determination of whether or not you can or should go on diversionary status. So here are the practical rules when it comes to diversion. Generally, you may divert persons who are not on ambulance property and who are not in an ambulance. So if you have a situation where you receive a phone call in the emergency room, this guy says, hey, I'm here with my wife. I'm bringing her into your facility. We're about 10 minutes away. She's in labor. She's going to have a baby. Well, that person's not in an ambulance. They're not on hospital property. So you could send them someplace else if you want to. But if they show up anyway, they're your patient and EMTALA is triggered then. If the person is in an ambulance, you shouldn't divert them unless they're on diversionary status, but that doesn't mean you can't talk to them about appropriate treatment alternatives or alternative hospitals that may be able to provide effective care, but don't divert them. So the conversation would be something like, hey, hospital, we're in an ambulance, this guy has severe head trauma, we're bringing him into you. You could have that discussion, say, okay, we will accept them if you come. However, we are a critical access hospital. We don't have the services that this particular patient needs. It's in the patient's best interest to bypass us and go directly to the regional medical center that's a trauma center that can help. But we are not diverting you. If you come here, we will provide the care. We are not on diversionary status, but we're just telling you it's in the patient's best interest to go to another facility. That is consistent with EMTALA. You can do that, but by all means, make sure that you document that you did not divert, that you told them what you would accept, but you were just advising them that it would be in the patient's best interest to go someplace else. Because quite often those EMS people, they don't think about that. They just document that that person was diverted. Do not divert an inbound ambulance unless your hospital is on diversionary status. Make sure if you do go on diversionary status that you document the diversionary status, including the time and bases for diversion. We haven't got a lot of guidance concerning how you handle diversionary status. For example, could you be on diversion for some types of care and not others, or some units and not others? There's not a whole lot of guidance from CMS concerning those issues. The bottom line here is, if you're going to go on diversionary status, though, you better darn well have a good reason, and you better document why and when you are on diversionary status. Whether or not you are on diversionary status, if that patient shows up at your facility anyway, EMTALA is triggered, and you got to do the best you can. You can't just shoot them out without jumping through the EMTALA hoops. What about helipads? Well, the rules for helipads are generally, if your helipad is simply used as kind of a bus stop, that the helipad is just, the helicopter is just going to stop at your facility and pick up that patient and send them and take them on, then generally that patient is not deemed to have come to your facility. EMTALA is not triggered unless that patient needs care at your particular facility or requests care at your particular facility. So here's the rule. If a patient is brought to your hospital for exam or treatment prior to transport to another facility, EMTALA applies to the hospital. The hospital must provide the screening exam, stabilizing treatment, and appropriate transfer. So if they bring that patient to you, want care before they're transferred or helicoptered out to another facility, EMTALA applies. If, however, another facility has already examined the person and your hospital helipads is just basically just going to be used as a bus stop, then generally EMTALA does not apply to your hospital. Instead, EMTALA probably applies to the other hospital that's operating the helicopter that's agreed to receive that transfer, unless if the person's condition deteriorates while at your facility and a request is made for exam or treatment by others at your facility, then EMTALA would be triggered for your facility. Now, so EMTALA only applies if the person comes to the hospital, which may include being in an ambulance. Well, the second issue for EMTALA's application is there has to be a request for treatment, or it has to appear that the patient needs emergency care. So EMTALA applies if the person presents at the dedicated emergency department. And by the way, the rules are a little bit different depending on where the person presents at the facility. If the person presents at a dedicated emergency department and a request for exam or treatment, generally any medical condition is made, or if the patient's unable to speak, a prudent layperson would believe the person needs an exam or treatment for a medical condition, then EMTALA is triggered, okay? At a dedicated emergency department, it doesn't really matter what they come there for. If they're seeking treatment, then assume EMTALA is going to be triggered. If the person presents someplace else on hospital property outside of a dedicated emergency department, then the standard is a little bit different. EMTALA is triggered if there is a request for exam or treatment for a potential emergency condition, not just any condition, but a potential emergency condition. And if the person's unable to speak, a prudent layperson would believe that the person needs exam or treatment for a potential emergency medical condition. So, just to recap there, person shows up at your dedicated emergency department, generally assume EMTALA applies, even if they're requesting, no matter what they're requesting, generally EMTALA is probably going to be triggered. If they're showing up at a facility or an area of your hospital outside a dedicated emergency department, EMTALA is only triggered if they show up and request emergency type care, or a reasonably prudent person would think that this person may have an emergency condition. Now, EMTALA does not apply to requests for clearly non-emergent care. The interpretive guidelines make this clear. So if a person just shows up at your ED seeking preventative care, such as an immunization, flu shots, or COVID vaccine shots, or community outreach, etc., or the person shows up and requests to perform a non-emergency test, they're not suffering symptoms, but they just wanted to get their blood pressure checked at your facility. Or there was some kind of pre-scheduled appointment where their physician said, hey, go down to the ED and I'll make arrangements and you can just get this test. The person's not showing up for emergency care. Instead, they're just showing up as part of a pre-scheduled appointment. Or if the police bring in somebody to just simply gather evidence, they're not there for emergency care. They're just there for an evidentiary test like a blood alcohol content or sexual assault or something like that. For those situations, EMTALA does not apply because there is no request that the patient's not seeking emergent care. Now, with that said, though, you have to be a little bit careful because the guidelines confirm that EMTALA does apply if a prudent layperson would believe that the person needs emergency care even if they didn't show up. An example might be if the police bring in somebody with a BAC for a blood alcohol content test, and the test shows that this person is just blitzed. In fact, they're in a situation where it could constitute an emergency medical condition, then in that situation, EMTALA would be triggered. If you think that the person is not showing up for emergency care, then you darn well better document that this person was not seeking emergency care, that they fit within one of these examples. Well, what about infants? Under the most recent versions of the EMTALA interpretive guidelines, that when that baby is born, they are deemed to have come to the hospital. So even if the mother was an ongoing patient, once that baby's born, EMTALA applies to that baby. That means that if the infant is born alive, that the hospital has to jump through the EMTALA hoops before they can transfer or discharge that particular patient, that infant. That means that the hospital would have to provide the exam, stabilizing treatment, or an appropriate transfer if there was a request for exam or treatment from the mother, or a prudent lay person would believe that that infant needs exam or treatment. Well, what about patients? This is kind of a little bit of a weird statement, but EMTALA doesn't apply to patients, at least as defined by the EMTALA regulations. EMTALA does not apply to patients at the hospital. That generally they don't need it. Remember that the EMTALA was enacted because to cover situations where the hospital didn't otherwise have a physician-patient relationship with that particular patient. Once the hospital assumes the care, a practitioner assumes care, then they have obligations and they don't need EMTALA because they're protected by malpractice or the conditions of participation. So once that person is accepted as a patient, then EMTALA generally doesn't apply. Okay, so when it comes to inpatients, EMTALA ends once the person is admitted as an inpatient in good faith. Or that means that they're admitted for bed occupancy with the expectation that the person will remain overnight. Once you admit them as an inpatient, then there's no longer any need for EMTALA, and EMTALA ends. When it comes to outpatients, the guidance makes clear that EMTALA does not apply if the person has begun receiving outpatient services other than emergency care, even if the emergency exists once, or an emergency arises once they're receiving the care. The typical example is maybe you've got a patient comes in for outpatient testing for like a cardiac stress test. That person's they're operating, running on the treadmill. Suddenly the person grabs his chest, rolls off the treadmill. It's clear the person may be having a heart attack. EMTALA would not apply in that situation. Now, the reason not is because you've already assumed physician-patient obligations, provider-patient obligations. You're obligated under the conditions of participation in medical malpractice law to take care of that particular patient, so EMTALA is needed. So if you fail to provide care, you may be sued for malpractice, but not for an EMTALA violation. So with a hospital, with a dedicated emergency department, if the patient comes to the hospital and they request an emergency exam or treatment and the person is not already an inpatient or outpatient of the hospital, then EMTALA is triggered. That hospital, if it has a dedicated emergency department, must provide an appropriate medical screening exam to determine whether the person has an emergency medical condition. And if that person does, in fact, have an emergency medical condition, or it appears that they might, then you've got to provide either stabilizing treatment or an appropriate transfer. So here's kind of the flow sheet. Patient shows up at your facility, you got to provide that medical screening exam. If the exam indicates there is no medical condition, no emergency medical condition, then EMTALA ends. You may transfer or discharge the patient, EMTALA is over. You may have committed malpractice, but EMTALA ends. On the other hand, if the medical screening exam indicates that the person does have an emergency medical condition, then you've got to provide either stabilizing treatment or an appropriate transfer, or stabilizing treatment while you work for an appropriate transfer. So let's talk about that medical screening exam. This is kind of the gateway for EMTALA. That patient shows up, you've got to provide an appropriate medical screening exam. In order to be an appropriate medical screening exam, it's got to comply with the following. It's got to satisfy the following. It has to be performed by qualified medical personnel, okay? That's a defined term under EMTALA. Qualified medical personnel are those persons who are identified in documents approved by the governing body. So some document, either a policy, bylaws, some document approved by the hospital board has to approve who are the persons who can perform the medical screening exam. That doesn't have to be by name. It could be by title. For example, in our ED, we staff it with physicians, so only physicians can perform the medical screening exam. It could be, if you use advanced practice professionals, you may authorize them to do the medical screening exam. In some circumstances, it may be appropriate to identify nurses as qualified medical personnel. For example, especially in like labor and delivery, you may want to identify nurses as QMPs to perform at least certain aspects of the screening exam. In addition to being identified in documents approved by the governing body in general, you need to make sure that those people who are performing the exam are competent to perform the exam and they have the appropriate privileges in order to perform the exam. So that's the first requirement. It has to be conducted by a QMP. Second, it has to be applied in a non-discriminatory manner. That means that the services, the exam you perform does not differ based on the patient's payment status, their condition, their race, their national origin or disability, etc. Certainly it will differ depending upon the symptoms, right? but you can't use any of these illegal bases for discrimination, including their ability to pay. And finally, most important, that screening exam has to be sufficient to allow the qualified medical personnel to determine with reasonable clinical confidence whether an emergency medical condition exists. Whether or not that exam is appropriate depends upon the presenting signs and symptoms and the hospital's capabilities, including on-call physicians. You're required to use the facilities and the capabilities that the hospital has available in order to complete an appropriate screening exam. If that means that you can call in on-call physicians to do that, then you need to do that. If that means that this person needs an MRI, then you need to perform the MRI, but it's only within your capacity and it's only based on presenting symptoms. All right, that medical screening exam, the guidelines make clear that it's an ongoing process and not an isolated event. In a couple of the EMTALA cases I've had, this was one of the CMS's citations that, for example, the person shows up at 0100 hours and there were, documented vital signs, and then there's no additional documentation of any continued monitoring or what happened until they were discharged at 0400 a.m. For 0400. So you need to make sure that you document an ongoing screening exam. That exam is not triage. Triage is not a screening exam. Triage just helps you determine who gets care first, but it does not constitute a screening exam per se. The screening exam may begin with triage, but it goes beyond triage, and it continues until the patient is stabilized, admitted, or transferred to another facility. That screening exam should normally include vital signs, a history, a documented physical exam of the involved area or system. If needed, you need to perform ancillary tests with specialists available through the hospital. For example, lab tests, diagnostic tests, whatever. And then finally, there should be continued monitoring while that patient's at your facility. When it comes to screening exams, this is really, really important. If it's not in the chart, it didn't happen, right? The government's going to look at that chart. In most of the EMTALA cases I've been involved with, I am convinced that there was proper care given. It's just a problem that the people didn't document it. So it's really critical for purposes of EMTALA as well as patient care that you document in the chart that there was an appropriate exam that was conducted. If the exam showed there was no emergency condition, that you document that. If the patient's stabilized, then document that the patient's in a stable condition. If the patient refused care or the exam or requested a transfer, make sure you document that. And in the case of a transfer, we'll talk about this in a minute, you've got to certify that the benefits of the transfer outweigh the risks. Now, that screening exam is designed to determine whether or not the patient has an emergency medical condition. If they do, then EMTALA applies. If they don't, then EMTALA ends. Malpractice may still apply, but EMTALA ends. Well, what is an emergency medical condition? An emergency medical condition is a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, psychiatric disturbances, and/or substance abuse, such that the absence of immediate medical attention could reasonably be expected to result in placing the individual's health in serious jeopardy, serious impairment to bodily functions, or serious dysfunction of any bodily organ or part, i.e., that they've got a condition that unless they get immediate care, that they're going to be in trouble. In the case of pregnant women, remember it's EMTALA, the Emergency Treatment and Active Labor Act. The rules are a little bit different. The standard for an emergency medical condition for a pregnant woman is, in the case of a pregnant woman who is having contractions, then generally they have an emergency medical condition if there's inadequate time to effect a safe transfer to another hospital before delivery, or the transfer may pose a threat to the health or safety of a woman or an unborn child. Now, you got to be careful because if a woman comes in, they're presumed to be in labor, okay? Labor is the process of childbirth, beginning with latent or early labor and continuing through delivery of the placenta. A woman experiencing contractions is presumed to be in labor and to have an emergency medical condition unless a qualified medical person acting within the scope of their practice certifies false labor after a reasonable period of observation. So if you have a situation, a woman shows up, she's really early in the labor process, and you think that she can go home, she's not progressing, she can go home and come back later. Well, EMTALA applies because she's in labor, and therefore, in order to send her home, you've got to jump through the EMTALA hoops for an appropriate transfer, which would include a discharge, unless you have a qualified medical person. Now, that can be a nurse if the nurse has been identified as a QMP by the governing board, unless a QMP or other qualified medical, unless the nurse or other qualified medical personnel certifies that it's false labor after a reasonable period of observation. In the case of psychiatric conditions, persons deemed to have emergency medical condition if they're expressing suicidal or homicidal thoughts or gestures, or determined to be dangerous to themselves or others. This seems to be increasing at our facilities. Just remember that those with psychiatric problems who are suicidal, homicidal, or determined to be dangerous to self or others, that they have an emergency medical condition, and EMTALA applies. It means you can't just send them home or send them someplace else. In the case of substance abuse, be careful of those situations. Substance abuse itself is not necessarily an emergency medical condition, but if it could result in harm to the individual, then that may trigger an emergency medical condition and trigger EMTALA obligations. Now, for that screening exam, you only need to perform a screening exam that's necessary to rule out an emergency medical condition based on the presenting symptoms. If the nature of the request is such that it's very clear that the person doesn't have an emergency condition, it doesn't mean that you have to jump through the full-blown emergency medical screening exam. So a person comes in and says, hey, I've got a hangnail. That doesn't necessarily require you to jump through a full screening exam, right? You just need to perform the exam that's appropriate based on the presenting symptoms in order to determine whether or not the person has an emergency medical condition. The standards for EMTALA are different maybe than malpractice. In order to avoid malpractice, you may need to do more. For purposes of EMTALA, though, you only need to perform the exam that's necessary to confirm or rule out an emergency medical condition. In the case of obvious non-emergency situation, the person's statement that they are not seeking emergency care together with brief questioning by the QMP would be sufficient to rule out an emergency medical condition. As with all other things, be sure to document to confirm that there was no emergency medical condition. If the medical screening exam reveals no emergency medical condition, then EMTALA ends. That means you may transfer the patient, send him someplace else, discharge the patient home. EMTALA ends. Make sure you document that determination. On the other hand, if the medical screening exam reveals an emergency medical condition, then you've got to provide either stabilizing treatment or an appropriate transfer. So let's talk about stabilizing treatment. If the medical screening exam reveals an emergency medical condition, you've got to provide either the stabilizing treatment or an appropriate transfer. Stabilizing treatment has to be provided within the capabilities of the facility, and is generally defined as that care which is necessary to assure within a reasonable medical probability that no material deterioration of the condition is likely to result from or occur during the transfer from the facility, or for pregnant woman who's in labor, the delivery of the child and the placenta. Okay. Remember that EMTALA ends once the patient is stabilized. Okay, your malpractice obligations don't end, your conditions of participation obligations don't end, but EMTALA ends once that patient is stabilized or appropriately transferred. Now note the different standards for stabilization. Under the regulations themselves, EMTALA, the patient is determined to be stabilized if there's no deterioration of the condition is likely within a reasonable medical probability to result from or occur during the transfer as a result of transfer, i.e., under the regulations, it appears to say so long as you could transfer the person to another facility without them suffering an adverse effect, then they are deemed stable for purposes of EMTALA. In the case of the interpretive guidelines, however, they actually, what I think, adopt a different standard. Under the interpretive guidelines, a person is deemed to be stabilized if the emergency medical condition has resolved, even though the underlying medical condition may persist. For psychiatric conditions, the person is protected and prevented from harming themselves or others. In the case of psychiatric patients, the guidelines warn that don't just assume that because you used restraints that person's stabilized, because when you remove the restraints, they may no longer be stabilized. So you have to be careful when transferring a psychiatric patient because they may really not be stabilized. Therefore, your transfer would have to jump through the hoops. So under the interpretive guidelines, it's not just a question of whether the person could be transferred to another facility without suffering an adverse consequence. The question is whether or not the emergency medical condition has resolved. Again, I think that's a different standard, but so be it. There it is. That's the standard you're probably going to want to comply with. Well, remember that EMTALA applies, or a transfer occurs not only when you send them to another facility, but even if you discharge them home, that's deemed to be a transfer. So when is a person stable for that type of a transfer, for the discharge home? According to the guidelines, a person stable for discharge is within reasonable clinical confidence the patient has reached a point where their continued care, including diagnostics or treatment, could be reasonably performed as an outpatient or later as an inpatient, provided the patient is given an appropriate plan or follow-up care as part of the discharge instructions. In the case of psychiatric conditions, that the patient is no longer a threat to themselves or others. So that's the standard for determining whether or not you could just discharge them home instead of sending them to another facility. As with all things, document whether or not the patient is stable. If you're going to discharge them or send them to another facility or send them out and you think that the person's stable, make sure that you document that. And I would use that language, that the person is stable. In the case of stable for discharge with pregnancy, again, for pregnant women in labor, stabilized means the delivery of the child in the placenta. If a woman is having contractions, the hospital has to deliver the baby in placenta, or the hospital must perform an appropriate transfer, including the discharge back to the patient's home. So even if you're going to send them back home, you need to jump through the EMTALA hoops to make sure that's appropriate, meaning that you would have to have a physician certify that the benefits outweigh the risks, or you'd have to have the patient request the transfer home, and then you'd have to document that. Remember that if a woman's having in labor, or having contractions, they're assumed to be in labor, thereby triggering your obligations, unless a QMP certifies that they're in false labor. The hospital has to provide stabilizing treatment within its capabilities. That includes the physical facilities, equipment, and services, and your staff, including on-call staff. You need to get them in there to help you provide stabilizing treatment. If the patient is stabilized, the hospital may admit, discharge, or transfer the patient someplace else without jumping through EMTALA. Remember, EMTALA ends once the patient is stabilized, but you're going to want to document that that patient truly is stabilized. If the hospital is unable to stabilize the patient, then the hospital has to effect an appropriate transfer to another facility. So again, stabilizing treatment. If the patient's stabilized or you admit the patient, EMTALA ends. Okay. On the other hand, if the patient is not stabilized and you haven't admitted the patient, then you've got to continue to provide stabilizing treatment or provide an appropriate transfer. What is an appropriate transfer? Well, if the patient is not stabilized, the hospital cannot transfer or discharge the patient unless you have one of the following. So you've got an unstable patient who's not stabilized. You can't transfer or discharge the patient unless one of the following occurs. Either the person or the personal representative of the patient requests the transfer to another facility, or the physician certifies that the benefits outweigh the risks. And in either of those cases, the transfer also has to be appropriate. We'll talk more about that in just a minute. But note that the physician, in order you can't transfer or discharge unless either the person requests the transfer or the discharge, or you have to have a physician certify the benefits outweigh the risks. We're going to talk about that more in just a minute. That transfer, as I mentioned, is any movement outside the hospital at the direction of hospital personnel, including a discharge. If the person leaves the hospital without permission, that's not a transfer, but you're going to want to document that they went AMA. If you move the patient from one area of the hospital to another, that's not a transfer because it's all within the hospital. If the patient requests the transfer, you can go ahead and transfer them. You know, EMTALA does not override patient consent. Patient still has the consent, right, or the authority to consent to or refuse care. But if they request the transfer, EMTALA states that the hospital must inform the patient regarding their EMTALA rights and the risks of the transfer, And the patient should complete a written request for a transfer that documents the reason for the requested transfer and that the patient is aware of the risks and benefits of the transfer. So you should have some kind of form for this. These are the requirements that EMTALA wants to see in those patient requests for transfers. Alternatively, if the patient doesn't request transfer, but you think it's appropriate, the hospital may transfer the patient if you get physician certification. That's the physician signs a written certification that summarizes the reasons for the transfer, the risks and benefits of the transfer. It states that based on the information available at the time, the medical benefits outweigh the risks, and the physician signs the certification form. That certification may not be backdated. Note that this physician certification has to be signed by a physician. An advanced practice professional is not enough. If the physician is not present in the emergency department, a QMP, which could be a nurse or an advanced practice professional, if they've been identified by the governing body as a QMP, they may consult with a physician and sign the certification, but the physician has to countersign that certification within the time required by the hospital bylaws or policies. So every time you're going to transfer an unstabilized patient out of the facility, you either need the patient's request and document that, or you've got to have the physician certification that the benefits outweigh the risk, and that has to be signed by a physician. In either of those cases, the transfer has to be appropriate. In order to be appropriate under EMTALA, and the transfer has to satisfy the following 4 factors. The transferring hospital has to provide treatment within its capability to minimize the risk of harm to the patient. The transferring hospital has to contact the receiving facility to confirm that that receiving facility has available space and qualified personnel, and that facility agrees to accept the transfer. You're probably, if you're going to transfer that facility or you're going to transfer the patient, you may want to document who that is. If you are a receiving facility, you'll probably want to identify those persons at your facility with the authority to accept the receipt of those transfers. And in addition, the transferring hospital has to send relevant records available at the time. If the records aren't available at the time of transfer, they have to follow up and send those after the transfer. Among those records that they have to produce is if they have to transfer the patient because one of the on-call physicians refused to come in, they've got to send the name of that physician to the receiving facility, presumably so that receiving facility can, narc on the physician to CMS. Finally, the 4th element of an appropriate transfer, that transfer has to be effected through qualified personnel with proper equipment, including life support measures. Now, the hospital is not required to maintain EMS to transfer patients. They may use that. That's kind of the standard. That's kind of the default. You may use a patient car in appropriate circumstances, but it's risky. I've had several of these EMTALA cases where CMS comes back and cites the hospital because they sent a patient in the patient car. If you're going to send a patient to another facility, an unstabilized patient to another facility using the patient's car or family member or something like that, you're going to want to document certain things to protect yourself. You're going to want to document that the method of transportation is appropriate, or that you offered appropriate transportation. My default is always offer the ambulance. If the patient refuses, that's fine, but document that you offered him and explain the risks and benefits and they refused it. Ensure that the patient is accompanied by appropriate family member, friend, or other person who can help out along the way. Give appropriate instructions. For example, go directly to the facility. Don't stop and, to go to a movie before you head to the other facility. And document the patient's refusal to accept an ambulance, transport, or other appropriate transport. As with all things, document. Document that there was an appropriate transfer, that you gave the patient other alternatives and the patient refused them. Well, what about those patient refusal situations? Again, EMTALA does not trump patient consent. The patient always has a right to refuse the exam or treatment or transfer you may want to provide. Your job is just to document that refusal. Under the EMTALA regulations, the hospital must document, they must offer exam, treatment, or transfer, document that the exam, transfer, or treatment was refused, document, and they specifically say you're supposed to document the treatment or exam that was refused, not just that the patient refused. Document that the risks and benefits were explained to the patient, the basis for the refusal. Take reasonable steps to secure the written informed refusal. So try to get the patient to sign that. If the patient refuses to sign it, document their refusal and why they refuse to sign it. So we need to have that AMA form in there. The patients may not coerce persons into refusing care or leaving the hospital. So under the EMTALA guidance, they don't want to see you kind of ushering that patient to the door, trying to convince them not to show up at your facility, including suggesting to the patient that they could get their care elsewhere for free or at lower cost. You can always answer questions honestly, but be careful in your discussions that you're not kind of encouraging the patient to go someplace else. And make sure that you remind the patient that the law entitles them to certain care even if they cannot pay. That doesn't mean they get it free. They're still obligated to pay, but even if they can't pay or they're financially insolvent, they're still entitled to the care. Under EMTALA, you can't delay or discourage the exam or treatment to inquire about payment. You cannot seek pre-authorization from the insurer until after you have conducted an exam and initiated a stabilizing treatment. You should not suggest to the patient that they should leave, that they could get care elsewhere at a cheaper cost, or that insurance may not cover their treatment. So you can't delay or seek pre-authorization. However, so long as it does not delay or discourage the exam or treatment, you may, even though, while the patient's still there, follow reasonable registration processes, such as obtaining their information, obtaining insurance information, getting their, identifying their emergency contact. It's just you can't condition treatment on the payment, but you can start that payment process. You can contact the primary physician or health plan to obtain a history or identify needs to help you provide the care, but you can't seek pre-authorization. If the patient starts asking questions, make sure your people know how to answer the questions. Again, you can answer honestly that yes, the patient will be billed for the services. Yes, the hospital is obligated to provide the care even if the patient doesn't pay. Those are the requirements for a hospital with a dedicated emergency department. What about other hospitals? Well, other hospitals that participate in Medicare, even if they don't have a dedicated emergency department, they're still obligated under Medicare to accept transfers if that other facility has specialized capabilities that the transferring facility does not. That could be specialized equipment, specialized personnel, could be mental health unit, a NICU, burn units, or so forth. So they have specialized units, or it could be a situation where the circumstances are such that they have special circumstances. Maybe that transferring facility is overwhelmed. Maybe they don't have, they had a power failure or something like that. And under the particular circumstances, that other facility has specialized care. Now that receiving facility may refuse the transfer if the transferring hospital has the same capabilities. You're not required to accept a transfer from the same level of care, but be careful about that, because it may not be that you really do have the same level of care. So be careful about asserting that. They're not obligated to accept the transfer if the transferring hospital had admitted the patient as an inpatient. Remember, once you admit the patient as an inpatient, EMTALA ends, not only for your facility, but also the receiving facility. So if you're trying to transfer a patient, you're going to transfer this patient to another facility, you may not want to admit them at your facility, because once you admit them, that other receiving facility is not going to be obligated to accept them under EMTALA. If that receiving facility, if a patient shows up at that other facility and that receiving facility believes that they've been dumped on, that the patient came to them per an improper transport or per an EMTALA violation, then that facility has an affirmative obligation to report the EMTALA violation. According to the EMTALA interpretive guidelines, you've got to report within 72 hours. That's a matter of professional courtesy. You'd probably want to call the transferring facility first, make sure that you really do have the facts necessary in order to make that report. All right, let's talk about on-call responsibilities. Under EMTALA, the hospital has to maintain an on-call list of medical staff members available to provide a screening exam and stabilizing treatment. The hospitals have flexibility in establishing how they're going to make that call coverage work. For example, you're not required to have 24/7 call coverage. You're not required to have call coverage for all your specialties. The government realizes that some of the specialists require payment for call coverage, and some of our smaller hospitals can't afford to pay that. So they don't necessarily expect you to have 24/7 or coverage for all of your services. In the guidance, they do state that if you're providing the services at your facility, advertising, for example, that you provide ortho services, then CMS would normally expect you to have some call coverage for ortho services. But I've never seen that really enforced. That's kind of aspirational, but I don't think they could ever come back against you and actually cite you if you didn't have call coverage. But that's kind of the general standard. You have to have written policies and procedures that cover situations if that specialty or on-call physician is not available, including appropriate transfer arrangements. You've got to have a backup plan if the hospital permits on-call physicians to have call at other facilities, and that on-call physician is not available to your facility because they're performing services in another facility. You've got to have a backup situation to address those cases. Not all medical staff members are required to take call. You can maintain an on-call. You have to maintain that on-call list by the individual, not by the group. So you can't just say that, Intermountain Orthopedics is responsible for this call. No, it's got to be by individual. So you work with the group to identify the individuals. That's so the government knows who to go after if that person fails to show up. You should require the physicians to respond within a set period of time. The government has said that if you fail to do that, then they may look to the hospital for EMTALA violations. You may use telemedicine in your EMTALA response in your responses to provide appropriate care. The on-call physician should come to the hospital and not have the patient sent to their office. So it's not appropriate for the hospital, for the on-call physicians to say, oh, to have the patient see me in the morning. That's not sufficient. You would have to do the screening exam and determine that the patient's stable before you could do that. If the policies permit, the on-call physician may send an advanced practice professional, but the physician ultimately remains responsible under EMTALA. If the treating physician determines that the on-call physician should respond in person, that on-call physician is obligated to come to the facility. They can't just refuse. Beware situations where you have informal on-call lists. I see this quite a bit in especially the rural facilities where physicians will say, hey, if you want to give me a call, if I'm available, I'll respond. Well, for purposes of EMTALA, you're either on-call or you're not. If you're on the on-call list, then you're expected to come. If you're not going to be expected to come, or you don't want to be expected to come, then don't put your name on the on-call list. You could have something that says these people are not on call, but they may be available. That's okay, but make sure you distinguish that so it's clear that this physician is not really on call on the on-call list and not subject to penalties if they show up. If the on-call physician fails to respond, then the on-call physician in the hospital may be subject to penalties. If the hospital transfers the patient because the on-call physician failed to respond, the hospital has to send the on-call physician's name to the receiving facility. To be safe, make sure that you establish call coverage policies, address call coverage requirements in your bylaws and policies, and your physician contracts. Train and retrain your medical staff and enforce your call obligations requirements. Otherwise, the hospital may be liable for the on-call physician's misconduct. You can, in certain circumstances, have a community call plan with other facilities to allocate call responsibilities. EMTALA does require you to post certain documentation. You've got to have your EMTALA sign in your dedicated emergency department. You've also got to have your emergency department log that you maintain someplace in some form. That log has to identify for everybody who shows up at the ED, whether the patient was refused treatment, whether the patient refused the treatment themselves, whether the patient was treated, stabilized, admitted, transferred, or discharged. This is the first place where the regulators are going to look. If they're evaluating your EMTALA compliance, you need to make sure that you maintain that log in an appropriate manner. When it comes to EMTALA, you've got to maintain records regarding individuals transferred to or from the hospital for 5 years from the date of the transfer. You must retain the original or legally reproducible form. You may maintain it in electronic form. In the interest of time, I'm not going to go through the rest of these, but the slides have several suggestions for what you can do in order to avoid EMTALA penalties. The main thing is make sure that you document. If you don't remember anything else, just remember this. When it comes to EMTALA, you're probably going to be okay so long as you have your appropriate EMTALA policies in place. You do what is best for the patient, and then document that what you did was in the patient's best interest. In those situations, the government may come in, they may tag you, but you should be able to do an appropriate plan of correction. You can avoid EMTALA penalties. If you need additional information, the government has a website dealing specifically with the EMTALA issues we talked about today. I've also got publications on our website, including the written materials that we provided you today. Just a reminder of the upcoming compliance webinar series that'll be finishing up this in the next couple of weeks. If you'd like to participate in those, you can go in and access those at our website. That is it. If you have any questions, submit those using the chat feature or send me an email and I'll respond as quickly as I can. I hope you're doing well and have a great day.